Hello, everyone. So now I'm switching to English because we have arrived to the English language section of our webinar, where we will have a discussion discussing how to market and make commercial communications without getting caught by the supervisory authorities within the Baltic countries. And I think it's particularly relevant because many businesses in our countries, in fact, operate across all three countries, Estonia, Latvia, and Lithuania. So it's very important to know how this issue is solved along and across our jurisdiction. Therefore, I'm very happy to meet here and to present our colleagues from Estonian and Lithuanian Sorainen offices. So let me introduce everyone. We will have in our panel our Estonian office senior associate attorney at law, Liisa Lotte-Laane. Liisa is a member. Hello, Lisa. Welcome. Lisa is member of our competition and regulatory practice group and also head of our Estonian life science sector group and very often involved also in solving various data protection assignments. Latvia will be represented by my dear colleague Julia Terjukana, whom I already introduced and who told us about the novelties in data protection. So welcome again, Julia. And Julia will also be leading this discussion. And finally, last but not least, we have our Lithuanian office colleague Irma Kirklyte, senior associate and attorney at law, who is the main go-to lawyer in our Lithuanian office regarding any data protection issues and also a member of our lifetime sector group. So welcome everyone. And now I'm giving floor to you, Julia, I think first. Thank you.
Yes. Hello once again, everyone. And please, Ines, switch to the next slide. During this part of our webinar today, we will discuss why we need to regulate marketing and why this topic is so hot still, even though the e-privacy directive, which regulates this topic on the EU level, has been here for 20 years already. We are currently on the way of adopting e-privacy regulation, but meanwhile, still local rules apply, and companies, when entering the Baltic market, oftentimes, and we see it from our everyday practice, ask us how rules for distribution of e-commerce and e-commerce related SMSs, phone calls, emails, various bulletins, how these practices vary from country to country. And probably at the first sight, we could think that rules are all the same, but no. And this is the aim of our today's discussion, to spot the light on those differences and actually to realize that many things are different. Today, we will discuss mostly and mainly e-commerce, which means communications sent by electronic means. We will not discuss here regular post, like email, not email, but envelopes, which you receive at your post box at home. We will not discuss anonymous leaflets, booklets, and brochures. These are not considered e-commerce communication when they are sent in physical manner, just like receiving them in post box. Next slide, please. At the beginning, I will briefly introduce the current regulatory framework in the EU, and then, together with my dear colleagues, we will compare how things work locally. As a general rule, e-privacy directive prohibits sending communication to individuals without their consent, meaning that unless you have ticked the box or checked the box somewhere, online when applying for some services or buying some goods online. If you haven't provided your direct explicit consent to receiving this type of communication, for example, advertising emails or SMSs, you are not consenting to this, and this business provider is not allowed to send you any. At the same time, e-privacy directive provides member states, just like Latvia, Lithuania, and Estonia, to adopt their own rules. For example, there is a rule that sometimes, alongside the consent, also legitimate interest can serve as another legal basis for distributing electronic communications. But some exceptions apply, and I will talk about them later. Also, member states can decide whether to apply these rules to businesses, to distribution of emails, SMSs, various electronic messages to businesses, whether it would be without any constraints or with mandatory consent, just like for individuals. If we jump to Latvia, could you please switch to the next slide? Here you can see the comparison for all three countries. If we switch to Latvia, there is so-called opt-in rule for individuals, meaning that individuals must check the box before messages are sent to them, and opt out for business-to-business communication. This means that if a business representative receives an electronic communication, such an email, this is not a breach, first of all, and it can refuse to receive such messages in the future. It must be for this business representative possible to unsubscribe from further communications. You can imagine some examples like sending some information about upcoming webinars, seminars, on-site events, participation in courses, just a simple promotion of business-related services and things you do in your daily life. At the same time, at least from Latvian supervisory authorities' perspective, it must be considered that such business communication shouldn't be outside the scope of regular business. It wouldn't be acceptable to promote. For example, I don't know, if I imagine that somebody sends me advertising about cosmetics, electronic devices, sales, and Black Friday offers to my business email, that would not be in line with those rules. And in Latvia, there is no public blacklist, which is also sometimes seen in other European Union countries. No public blacklist of, for example, list of individuals who have stated that they no longer want to receive any electronic communications from anybody. There is no such list in Latvia. At this point, I would like to ask my Estonian colleague how the situation is in your country. Is it similar to Latvia, or is it different?
Thank you, Julia. With regard to blacklist, you mean, or in general?
In general, regarding this opt-in and opt-out.
Yeah. In general, Estonia is very similar with Latvia. The main rule which have to be borne in mind is that, as a rule, you have to have consent from the individuals if you would like to send direct marketing materials to them, and opt out for businesses. However, what is may be important to bring out that with regard to marketing communication, in certain cases, also individuals might be considered as legal, as a very important person of this legal entity of the business. And in that case, you may still send the marketing materials even to individual under the rules applicable to the legal persons. For example, if you would like to send direct marketing materials to a director responsible for the purchasing of different products, then of course he or she is a suitable person for receiving such direct marketing materials, and you may rely on this opt-out version. So basically, I see that Estonia and Latvia are pretty similar on a high-level regulation.
Okay, thank you. So we see that among the Baltic sisters, here is kind of our twin. Estonia and Latvia are quite similar in this regard. And what about Lithuania? I've heard that things are different there.
Yeah, I think that it's worth mentioning maybe two main differences comparing with Latvia and Estonia. The first one, that cold calls are not allowed in Lithuania. And so calling both natural and legal person is not allowed without having a prior consent. It's also worth mentioning that this restriction applies despite the source or the phone number is received from. It can be published on the entity's website. It can be received from your colleagues. But this restriction even applies when calling a randomly generated phone number. And moreover, calling without prior consent, but with the purpose of obtaining such a consent, is also prohibited. And in case the phone number belongs to the individual, so this consent must be provided by this individual. And in case the phone number belongs to the legal entity, consent must be given by the CEO or the company or another authorized person. And maybe another main difference is that the same rules as B2C applies also towards B2B. So it means that a prior explicit consent of the recipient is also required when you are approaching businesses. So I think it's the very big difference comparing with other EU countries, because Lithuania has implemented e-privacy directive more stricter than other countries, and as a result, we see that there are no differences between approaching natural persons and legal entities in Lithuania. And of course, so again, therefore, it's necessary to obtain a consent of the CEO of the legal person or another authorized person. Or, as Julia, you already mentioned, maybe it's worth for looking for exception for existing customers to assess whether soft opt-in can be applied in this case.
Thank you, Irma. This is very interesting. I wonder how businesses communicate to each other just to move their things forward. And also, from Latvian perspective, the soft opt-in applies only to email communication. It doesn't apply to phone calls. How it is for Lithuania, and maybe Lisa, you also later can comment from this perspective.
Yeah, you have a very good question, because they have the same rules, not just for like text, not just for emails, but also for these phone calls, because there is such terms as subscriber or user, and this also is applicable for phone calls. So therefore, even when calling, so the same rules applies. And talking about the fines, or Julia, as you mentioned, so how business communicates in Lithuania. So I think that the common practice is that they still, they use these cold calls. They still send these emails, because at the moment there are no publicly available decisions about fines. We are aware of one case when B2B marketing took place via email without prior consent, and the fine was imposed on the responsible person, and the fine was approximately 300 euros. So I think that businesses in Lithuania, so they do understand the risk, and they assess that the fine is not so huge, and they take the risk, to breach this legal requirement.
Oh, thank you. Okay, and Lisa, what about this soft opt-in in Estonia?
Yes, in Estonia it is applied similarly as in Latvia. Well, basically, if the individual has ordered a similar product or services from the company, then basically under certain circumstances, the company may still send direct marketing without asking a new permission, basically. But of course, always there must be a very easy possibility to withdraw the consent and to decline any further direct marketing. Also, what I wanted to maybe bring out is that a few years back we had this case where the local authorities, the Data Protection Inspectorate, they carried out a proceeding against one loan provider. And the question was that if a person had started an application to take a loan, then whether this this application was left unfinished. So basically, there was no contract concluded in the end. And the question was whether the company may continue sending reminders, you did not finish your loan application. Maybe you would like to reconsider. And then in such case, the authorities said that the soft opt-in would not be applicable there because there were no valid contracts in place, and that must be observed. But maybe also what should be brought out compared to Lithuania is that in Estonia, multi-party voice calls, which are in real time, they are always allowed. And you may initiate the call unless the robot is talking. And but of course, if the individual person is declining to receive such communication, then this must be respected.
Thank you, and thank you for this very interesting example with the loan company. As Irma mentioned already, sometimes businesses are willing to take the risks, and from what I see in my practice as a consumer, I oftentimes see that these SMSs and emails are sent without option to unsubscribe, especially the SMS messages. This is one of the most often, I think, mistakes what businesses take here. Also, very often they are sent from unresponsive phone number or unresponsive email address, which is prohibited actually by law. You cannot send it from an unidentifiable source. This is also important aspect to talk about, that actually those messages must comply with general advertising rules and also fair consumer practice rules. It is not possible to send messages that are just trying to, increase the hype that, hey, there is upcoming sale, click on this button, just clickbait messages. The source, the sender must be identifiable, and also the actual content. For example, this store will have discounts next week. What are the most common mistakes which you see in your practice as consumers?
I think that you also mentioned a very good example of not providing a unsubscribe option, because the requirement is that it should be simple withdrawal. And yes, the same with the identity of the sender or this business entity which sends these commercial materials. I think that, is also the most common mistakes that business make in Lithuania.
And And maybe regarding Estonia, the same mistakes, but I would also bring out this that last year, or was it year before last year already, we had one case where a company got precept because they basically ignored the withdrawal of consents. So although the person had this possibility to withdraw consent in the direct marketing materials, well, basically it was not recorded by the company, and the person still got the direct marketing materials in the future. So this is also a quite common mistake made by the companies.
Okay, thank you. And maybe as a final aspect to discuss, Irma already mentioned that there was a fine of several hundreds euros, but in general, we could say that this is not a very high fine. And honestly, I haven't heard of any recent fine in Latvia also. At the same time, I would say that in general, the public and the consumers are aware of their rights. And this commercial communication is that place where consumers meet the business and receive the message directly in their pocket most often. And if they don't want to receive any, and if they see mistakes, they become sometimes angry, sometimes reach out the company. And interestingly, that our local data protection supervisory authority said that in some explanatory guidelines a few years ago, if I'm not mistaken, year 2021, that consumers must take also this responsibility and reach out to businesses before complaining to the supervisory authority. And only if he or she has already requested to stop sending these communications, and also if he or she has received not less than 10 messages, only then this individual can complain to the supervisory authority. This is an interesting detail. Is it something like that in your countries?
No, regarding Lithuania, so we don't have such a rule. So you can just, send a claim directly to the authority, and then you can fill this claim, and you can just ask for fine. You can ask for some remedies and so on. So there is no like prior step to contact the business. And talking about these fines, also maybe it's worth mentioning that usually what we see in Lithuania, that these fines are imposed only when someone really sends a claim to the supervisory authority, or maybe these irregularities are found during the inspections by the authority. And so maybe if the customer is not proactive, and if the customer doesn't send a claim, so sometimes these often seen mistakes like not providing subscriber options. So maybe it also might be not noticed because there are no claim, and the supervisory authority cannot react to it.
And regarding Estonia, there are also no such fixed rules when you can turn to supervisory authority. If the infringement exists, then this is your possibility to choose the means.
Fair enough. Okay, thank you. We are just on time. Thank you, dear colleagues, for your insight in this topic. We wish all the businesses and business representatives to follow the rules. We wish all the individuals to know their rights. And if you see and feel that the businesses are breaching your rights, be brave and turn to them and ask to change their policies and change their behavior. And now I'm giving the floor back to Eva.
Thank you for colleagues for a very interesting discussion on commercial communication. And we have now turning to the questions and answers section I will actually start with the questions regarding your discussion, because we have received 2 questions exactly on this topic. So the first question would be, is there any time limit when marketing messages are not allowed anymore? I understand this is meant to concern the situations when there is a continuous marketing communication to previous customers. So, for example, a product was sold 3 years ago. So, is it still okay to send marketing email to a previous customer? Probably Estonia can start with answer.
Yes, thank you. So, Estonian authorities have not issued any guidances, or I'm not aware of any decisions where the authority has discussed such issue. There are no official time limits when you still can rely on this soft opt-in. But this is coming just from the general understanding of the GDPR and also direct marketing rules, that be reasonable in that regard, and consider whether you have this connection with the consumer. If in the question I understand that there was this 3-year term, I would say that if the 3-year term is considered with regard to some more expensive products or some more rare services which you don't order on a yearly basis, perhaps, then you may still have this reasonable basis to rely on the soft opt-in. However, if we talk about something very small, more like a product which persons use on a daily basis and maybe buy regularly, then I would say that you would still require a new consent for the direct marketing.
Thank you. How about Latvia?
I would say for Latvia, you can stick to the same logic as in Estonia. We have seen from our practice that some companies use 2 years for this period when you still can rely upon a soft opt-in. But yes, it would definitely depend on the type of service or type of goods which you have purchased. And our local authority hasn't issued the new guidelines. There were guidelines some years ago, but they are not published online anymore. And if I remember correctly, there were no information about this period for soft opt-in. So we just can rely on the logic that for long-term services or rare purchases, we can use longer term, and for smaller purchases, we can use shorter period of time.
And the same applies in Lithuania, because we have to keep in mind, that storage limitation principle established in the GDPR applies, that says that you have to keep in storage data no longer than it's needed. So therefore, I know, of course, every business they should set the rule. So what is like the reasonable term that is necessary to keep this data, and so which client is the active one, and which client can be considered as like not active and maybe not a client anymore.
Thank you. And another question for all 3 countries, and that's a tricky one, I know. So about self-employed persons, should they be considered as businesses or as private individuals in the context of marketing content? So this time, let's start with Lithuania.
Yeah. So this, we also don't have like official guidance or I don't know, some decisions from the authority, but the logic is just that even a natural person, if this person acts for business purposes, not for his own like household business purposes, so it's considered as like B2B a participant. Therefore, the same rules apply as for legal entities.
Thank you. And how about Latvia?
Yes, in Latvia also, in the course of business relationship, the self-employed person would be considered as a business representative, and therefore the same rules as for business would apply. If you are interested to hear more on this topic, we had the same webinar just a year ago, and my colleague Anna Bogdanova explained more about this commercial communication, and she mentioned specifically the self-employed aspect.
Thank you. And Estonia?
In Estonia, it's the same. When the actions of this individual person are attributable to a legal person, then of course you would have to follow P2B communication rules.
Thank you. Now we have a question concerning specifically Latvia, but I think it would be also interesting to hear how it is in other countries. And it's about cold calling. Cold calling to existing clients. And is the understanding correct that it could be done without prior consent if the call is about a similar product purchased previously? So, Julia, is this understanding correct, or do we have any nuances here to consider?
Yes, I think what you just said is correct. Typically, as a cold calling, we understand like calling to complete stranger randomly. So in this case wouldn't be just a cold call. It would be like a warm call to call to your existing client from your database. But if I understand correctly, regarding the different matter, which was not related to your previous service. So yes, for business it would be okay. For consumers, it wouldn't be okay to rely on the previous on this soft opt-in.
And how about
one aspect, you actually in Latvia can rely on soft opt-in only for emails. So no soft opt-in for calls.
Yeah, that's a very good note, exactly. And how about Estonia? In this regard, how do you consider calls?
Well, here it seems that we have found the differences between Estonia and Latvia, because under the Estonian laws, as I previously brought out, the multi-party calls which are taking place in a real time, they are expressly out from this direct marketing regulation concerning activities carried out by the electronic means, which means that basically cold calls fall under such multi-party real-time calls, and you do not require consent even if we talk about consumers. However, I think this was also on the slide pinpointed that in case you would like to call to any person, then you still have GDPR to consider, which means that if you would like to make a cold call, for example, then you should have at least legitimate interest as a legal basis for processing this individual's the personal data. And of course, when a consumer expressly prohibits such calls, then you can never do it again.
Thank you. And now the final comment for Lithuania about calls.
Yeah, so maybe my answer would be a very short one, because it's not allowed to call neither warm calls, neither cold calls without prior consent, and it also applies to both natural and legal persons. So no calling without prior consent in Lithuania.
Okay, that's very clear and straightforward advice. And actually, this is a good point where to finalize our webinar, because, well, no calls in order not to disrespect privacy, as all the ultimate goal of data protection rules is to protect our privacy, both of our society and also of us as private individuals. And that's our goal as lawyers here at Sorainen, to help you understand those often complex data protection rules so that everyone can be compliant with the requirements of privacy laws. So thank you very much for your attention. As I said, the materials, the slides will be sent to you by email. Also, recordings will be available later. And we were very happy to see you here, and you are welcome to follow the news from Sorainen regarding our next event. Let's stay tuned and let's stay in touch. Have a nice day. Bye bye.